This is Anita Bernstein, the Anita and Stuart Subotnick Professor of Law at Brooklyn Law School, to discuss the T.J. Hooper. Welcome, Professor Bernstein.
Thank you, Rick. It's great to be here. Welcome, audience, watchers, and fans of the museum. I'm delighted and honored to be the conveyor of this eternally interesting 88-year-old case.
Yeah, well, it is an interesting case. So tell us about it. First of all, what happened? And then why is it an interesting case?
I think all the classics of tort law are most important when they continue to have vitality beyond their time and place. They seem to move to a different location and are important. They speak to modern dilemmas and pressures. And I want to sort of take away a couple of 21st century applications or insights of this decision after talking about what happened to this thing called the T.J. Hooper. So let me start by talking about this boat by the name of T.J. Hooper, its ill-fated journey along the eastern coast of the United States, and then what brought it to the Second Circuit, where Judge Hand, Learned Hand, was able to give us this memorable and enduring opinion. The case dates back to 1932, and it is signed by three judges who are all prominent. Learned Hand is the most famous of them, one of the great American judges of all time and a landmark figure in the 20th century. The other two judges were first his cousin, Augustus Hand, who was, I guess, in Learned Hand's shadow for his career. And the third judge was Thomas Swan, who had been the dean of Yale Law School and died with his boots on at age 97, not yet having retired. Very prominent men, and in what I think we could say was the most important of the federal circuit courts at the time of the decision. The case is called T.J. Hooper, named the vessels, one of the boats that went to Davy Jones's locker after the accident happened. And the case is in federal court, which is unusual for a tort claim, a negligence kind of action like this, because it's eligible for Admiralty as a source of federal jurisdiction. Harms or incidents or mishaps that involve navigable waters that get from one place to another, typically involving boats, can get to the Admiralty docket, which is like a regular American court in most respects, but has a couple of differences. In another famous Admiralty case by Learned Hand, which is called Carroll Towing, the Admiralty nature of the problem led to the focus on the plaintiff's negligence. It was actually the claimant that had been careless in Carroll Towing, because Admiralty was relatively progressive 100 years ago in that it didn't automatically regard as killed and defeated any claim involving negligence where the plaintiff itself or himself or herself was negligent. So that's a distinction between regular tort law at the time, which had an absolute defense of contributory negligence. Another distinction of Admiralty was that disputes of fact went to judges. Juries were not involved in Admiralty cases. And so unraveling what happened, figuring out how the collision occurred and whom to blame for it was a task for a judge rather than a jury. Mm-hmm. Now, in tort, we, at least as I think of negligence, we have a kind of four-part analysis of a claim. First, we ask what happened, what's the injury. Then we ask, and assuming it was accidental rather than intentional, we ask whether the defendant owed a duty of care to the plaintiff. And if the answer to that question is yes, we ask whether the defendant breached that duty. And lastly, we ask whether the breach of duty was the cause of the injury. Causation links the injury with the misconduct or lapse on the part of the defendant. Now here in T.J. Hooper, the issue is all about the breach element. There's no question that these participants in the accident all owed a duty of care to one another. They couldn't get away with unreasonable conduct. And it's also clear that the lapse on the part of T.J. Hooper, which is what Hand focuses on in this case, is related to the injury. The injury is destruction of boats and the loss of cargo. Barges carry cargo and tugboats lead them. So I have an image that I would like to share, and I'm not finding it, so that I will not like to share it but we'll bring that in later. Sorry, Rick, this has to be, of course, edited out. I don't know why this happened. I have the images ready to go, and they're just not here. Let me try saving it. Okay. We'll have to do some creative splicing.
Yeah, we can do that.
Yeah, I'm just not advanced. PowerPoint is virtual. Yeah, I share screen just fine with my students. All right, so we'll have to do it without images. That's a shame because I like the images.
There we go.
Oh, you see it here. Okay.
Yes.
So here's an image that I got from Googling. It's a Wikicommons a licensed one, so feel free to reproduce the image if you want. And you see there are two boats here. The brains of the operation is on the left. That's the tugboat that is captained, and it has people who are thinking and making decisions. That's what the court is focusing on in the latter part of the decision. And the dumb boat is the barge. It's flat. It's very thinly populated. It doesn't have controls to speak of. The word barge, I gather, comes from an Egyptian word meaning basket boat. So it's a very passive instrument. And these two vessels together are a way to move cargo from one point to another, putting the cognition and the planning up front and leaving the cargo in the back. So this is how the cargo was transported, and this is what went bad in the when bad weather ensued. Now, the breach of this controller, the operator of the tugboat, is perhaps best seen by the image of a map. So again, we'll have to cut this in later, Rick. I hope we get to an editable part. I'm going to close out the tugboat image and try to open up the PowerPoint of the map. The map, I sent you the image. Mm-hmm. Okay, is it visible now?
No, I'm still seeing you.
Okay, so let's share screen. PowerPoint is virtual. No, content from second camera. I don't understand why this is happening. I may be able to find it. With this PC and downloads a TJ Hooper image slide. That's okay.
Okay, now I see.
Now it's visible. Here's a map that was prepared by an artist, in which I have been kindly given permission to use. You see that the original point of the destination, the journey starts in Norfolk, and what is going on with the background? Are you seeing like a fake white screen, Rick?
I just see white screen behind the diagram.
Okay, that's distracting. I don't have any fake screen. I have no idea what's going on here.
No, all I think I'm seeing is the image as it's loaded on your computer.
You're not. Oh, I'm seeing a version of myself. It looks like it's a fake kind of green screen kind of look. I'll get back to the explanation of the journey.
Okay.
TJ Hooper and its dumb barge starts heading north along the East Coast. And you see on the map that at the location of the sinking, we've just gone by the Delaware breakwater. So that's a point as one heads from Virginia to New York, one passes the Delaware breakwater on one's left. And soon after getting past the Delaware breakwater, not stopping there, the TJ Hooper ends up sinking. And so this is the image of what occurred, and the timing of the accident is noted as well, March 8th to 9th at midnight. The reason I want to show the map is that the Delaware breakwater turns out to be important for the fault or the breach aspect of what the TJ Hooper was accused of. The TJ Hooper, in this case, was accused of poor choices, bad boating, as it were. And I'll talk about the TJ Hooper as a thing. That's one of the tics or practices of Admiralty law. It names boats and seems to think of them as persons. So I'll talk about the master of the TJ Hooper and the TJ Hooper. This is the star of the show, the most important character in the decision. Learned Hand, by the way, also says that the barges were negligent. The barges were negligent because they were not seaworthy. They were not equipped to withstand the penetration into the vessel of water. That's a lapse on the part of the people who own it and control it. And so the barges are not innocent here. They're innocent in the colloquial sense. We don't really talk of innocence and guilt in tort law. The barges are, the barge is negligent, and the TJ Hooper is negligent as well. Now, getting back to that map, if you envision the captain of the tugboat duly heading north, it turns out the weather is getting bad, and the reason that the cargo was lost and the injury occurred was that very strong winds arose, and we ended up with a kind of shipwreck. If the captain or master of the TJ Hooper had known about the alarming weather, he would have probably, we think, chosen to turn left, as it were, into the Delaware breakwater and hang out. But he did not do it because he didn't know about the weather being bad. The weather being bad was a piece of information that other tugboats at the very same time were receiving. At that time, and this is 1928, I guess, the weather forecasts and weather predictions were announced on the radio, by no means at the level and frequency that they are today. Now, if we want to know the weather, we whip out our phone, we have an app. Back then, 100 years ago or close to it, what you did if you wanted to know the weather was play the radio, and at the time there would be two broadcasts about the weather, one at 10 a.m. and one at 10 p.m. This is important information if you're vulnerable to the harm that bad weather can do. And as it happened at the trial, testifying before the judge, other tugboat captains, I believe there were 3 of them, reported that they had heard the news about the weather out of a broadcast in Arlington, Virginia, near south of where the injury occurred. And they thought, uh-oh, we're not going to keep going. It's dangerous. And they took shelter and just rested in the Delaware breakwater where they could, and got waited past this alarm or problem. And then after the weather calmed, they were able to leave. The captain of the TJ Hooper did not have this information because he had not listened to the radio. And why did he not listen to the radio? Or he didn't have one in working order. And that's the issue of the case. This is what the decision is famous for. This tugboat, having heard of radios, aware of the invention, did not choose to equip the tugboat with a working radio. And that is what Learned Hand and his fellow judges blame TJ Hooper for. That is the reason they were negligent. The correct thing to do, the right path rather than the wrong path, would have been to have a radio and turn it on. And then with respect to the causation element of a negligence claim, it's reasonable to infer that a tugboat captain who knew about the weather forecast because he had a radio and because he tuned in at 10 a.m. and 10 p.m. would not have been out there in the dangerous waters, and the cargo and the vessels would have been safe. A Learned Hand and his colleagues blame the TJ Hooper for not having a radio. So I have the decision here in front of me, and it says that the masters, that's what that hand refers to as, uses that word for ship captains, did not have any access to broadcast because their private radio sets, which were on board, were not in working order. That's they were there, they just didn't work, and it's careless not to have working radios. These belonged to them personally and were partly a toy, partly a part of the equipment, but neither furnished by the owner nor supervised by it. The problem or phenomenon we have here is that of the early adopters. At the time, in 1928, some people thought that this radio idea, the idea of radio as equipment necessary or desirable for the operation of a tugboat, was a cutting edge idea, the way a new model of our phones or an app might be something, those are less consequential, but it was a development on which the industry had not yet coalesced around what the case is known for, a custom. When the entire tugboat sector is not sure if it's necessary to have a radio on board, it becomes a bit of a usurpation, possibly, for a judge to say, I know how to be a tugboat captain better than you. Now, the court is aided by the expert testimony of those 3 other boats that made the prudent decision. And Hand observes that when courts listen to expert witnesses, only rarely do they have experts who could say, not only would I have done that, I did that. It's unusual for an expert to have actually been there on the scene, facing the exact same risk that the person who lost the property or the person responsible for the loss faced, and making a more prudent decision. So Hand finds it very compelling that these people not only know how to operate a tugboat correctly in the right way, but also live by what they said. They were not speaking about what they would have done. This, to Hand, is a reason to think that the industry is lagging And the sector needs to be reminded in the form of a goose, a pressure on the part of a federal court in Admiralty to change its dangerous ways and adopt something safe in its place. The most famous line in the decision is, courts must in the end say what is required. There are precautions so imperative that even their universal disregard will not excuse their omission. So in other words, this was a disregarded precaution, but Hand thought it was the right thing to do, necessary and desirable. And so he concludes that the tugboat operated by its master was negligent, and for that reason, it can be faulted under the breach element of the negligence prima facie case. So that's what the decision is about, and I think that although most of us have not been inside a tugboat and aren't shipping coal in a barge, I think we're instructed and edified by the decision.
Yeah, and it's interesting to note that the decision basically gets ahead of the industry.
Exactly.
The industry has not yet adopted a standard requiring radios.
Mm-hmm. Yes.
And Judge Hand says you need to have radios.
Mm-hmm.
We
Right.
are going to
That's
find
exactly right.
failure to do so
Mm-hmm.
is negligent. Or
yes, we know from the vantage point of where we are now, and I first encountered this case in the 1980s. When you say ahead, you're right, that Hand was right about radios. We don't dispute the wisdom, the desirability of having radios on board, but you only know ahead after the fact. It's possible, I guess, that a court could believe in quackery of some kind or something that a sector ought not to do, have absurd faith in its own righteousness, and go ahead and rule that someone was liable in tort or had breached a duty, even though it was mistaken as a matter of fact. So we remember Hand because he got it right, but you don't know when you're a judge. I hope that before signing off on this decision, Hand asked himself whether he was sure. And again, he was very aided by the expert testimony right there when these people who live by the sword of bad weather are saying that they would have taken the precaution. I think in other applications of this approach to a claim of negligence, where whether the defendant or an actor breached a duty of care is disputed, courts ought to be hesitant. They should go ahead, I think, but they ought to be reflective before they supersede or kind of override the so-called universal disregard of what the court thinks is reasonable.
yeah, it's interesting because I think at one point in the decision talked about sailors using binoculars as an aid to vision.
Yes.
And thought that radios would be another source of useful information.
Mm-hmm.
And so you get
so it seems obvious to you. You think that there's no question, even in 1928 or 1932, that the industry is wrong and Hand is right.
It seems that way.
Yeah,
but again, we're looking at it 80 years down the road, looking back at it.
Right.
The other thing that's interesting, in the Carroll towing decision, the same judge explicitly laid out a sort of, what I'm going to use the wrong term, cost-benefit analysis in assessment.
Right. I think that's a fine term for Carroll towing.
But in the T.J. Hooper, he didn't really address the cost or availability or reliability of radios. He just sort of took all of that as a given.
Right. Yes, and that I think is something that he ought to have thought about. This decision is older. We can't really blame him for not following Carroll towing because he hadn't written it yet. But there is an inconsistency where in the later case, Hand insists that think about a precaution. We have to consider what does it cost and what do you get from it. That's why I think the Hand formula, as it were, the comparison of the burden of a precaution against the expected cost of the accident, that really is cost-benefit analysis. And there's nothing in Hand's review of what the right thing to do would have been that takes into account the cost of the radios. I think suggesting that they were partly a toy and sort of taken on as a hobbyist instrument, that implies that he thought they were cheap, and I guess that's right. But we don't really know how cheap mandatory radios would be. I think in looking back on negligence actions, and I mention this to my students sometimes, it often looks very clear that a precaution should have been taken, because we know the end of the story. We know that somebody got injured, but precautions are done in advance of injuries. The person who invests in them is definitely going to pay whatever cost it is that is required, but hasn't yet seen that the investment will pay off. And so it's a little bit anachronistic, maybe, to say that cost-benefit analysis it can be known in advance. We don't really know the value of the investment until we see sort of living proof that the harm would occur. Right. Yeah, I don't know. But you're not suggesting, Rick, are you, that the decision is wrong because it wasn't mindful enough of how pricey the mandatory precaution would be, are you?
No, I think it's interesting because it retains continued vitality as a sense that the court is clearly staking out its turf, saying, we have the authority to say, you guys, whatever industry you guys refers to,
right,
have an obligation to keep up with the times.
Yeah, yes.
In a sense.
Yes, yes. And it's not only the new innovations or the modern developments or the early adopter temptations objects. When I talk about T.J. Hooper in my torts class, what I compare it to is a 1974 decision by the Washington Supreme Court. So it's quite old, it's older than my students, but it's somewhat more modernish, I guess, than the 1932 date on this decision. And there, in a medical malpractice action called the Helling against Carey, the Washington Supreme Court figured out what ophthalmologists should do routinely for all their patients, even though they were not doing it. And the plaintiff couldn't get an expert witness to say this was reasonable care because nobody was doing it. The precaution there is a routine tonometric pressure of eyes during eye examinations to look for asymptomatic glaucoma. And this was not routinely done 60 years ago. It is now with the help of the influence of this decision, which was overruled, I guess, pretty promptly by the Washington State Legislature, but read and taken seriously in its time. And there, the court was so confident that it had called this one right, that it remanded ordering a judgment for the plaintiff, saying, based on the undisputed facts, because we have decided that glaucoma pressure tests for patients under the age of 40 is the standard of care. And clearly the defendant doctors didn't do it. That's off they go. They can't possibly win. That's bolder than T.J. Hooper. I guess Helling is in the context of an access to a jury trial. So judges doing what they want is baked into Admiralty. That's not necessarily arrogant, for them to make decisions. They're the only ones who do. I don't know. I think that makes me uneasy, especially since medical malpractice law is pretty confident that the plaintiff in general needs an expert to talk about the standard of care. I don't really know how a judge in Washington State can know what the best, or not the best, the correct standard of care for the practice of ophthalmology can be. But as we think about what insights or takeaways we can extract from T.J. Hooper, there are a whole variety of behaviors that people are doing the way they do it, and these behaviors seem reasonable to the individuals who are engaged in these activities. But when a different way of doing this activity could have avoided an injury, T.J. Hooper keeps open the possibility that a judge will conclude that the choice of people who are talking the talk, walking the walk, living with the difficulty that they created, did not think was the standard of care. And so it's near the edge of usurpation or impertinence, I think, on the part of judges who are telling people what to do when they don't have to live with the consequences of that choice.
Yes. On the other hand, or to build on that, I think it also serves to prevent industries from ossifying and saying our habitual custom has always been and will always be the way we need to do things. Right. And the court is saying, no, that may routinely normally be the case, but you have to pay attention out there because things and events and products and behavior and circumstances change. And you can't just simply say our old custom is the end all and be all. So right. I think it's an important decision in that regard as well.
Yes, but I have to ask you, do you think that how to be a doctor is in the category of what you're talking about? Do you think that juries and judges know about, like, for instance, in obstetrics, whether the doctor delayed unreasonably long and should have done a C-section or a induction of labor? Is that the category of lay input and modernizing or guiding a sector to do things differently? Or would you say that's different from a technology adoption like radios?
Well, it's interesting, and I'll answer your question first with a plug for the museum. People who are watching this is why the museum is so cool, because you see how people, professionals, legal scholars like Professor Bernstein, approach these questions. The parameters, the metes and bounds, the limits, the what ifs, all come into bear here as we're discussing these cases. Now, in response to your question, let me pose another question. Would it be acceptable today for a surgeon, and I know my example is already flawed because I know there's a national standard of care for medical malpractice, but could a surgeon come in and say, look, I don't hold with this newfangled anesthesia the way I do it, the way my parents taught me and my teachers taught me is we operate by letting the patient bite a bullet.
Right,
I don't need anesthesia.
Right,
I think a court could reasonably say, even in the absence of expert testimony,
mm-hmm.
Hold on a second. The world has changed. Anesthesia is out there.
Mm-hmm.
You cannot persuade me, even if your colleagues are not using anesthesia,
Mm-hmm.
that failing to use anesthesia is acceptable.
Mm-hmm.
So I think there is some slack in the system that allows courts in certain circumstances, and it has to be dealt with on a case-by-case basis.
Mm-hmm.
But I think there is enough slack in the system so a court could say, hold on, wait a minute, what you used to do
Mm-hmm.
doesn't work anymore.
Mm-hmm.
It can cause harm needlessly, preventably, and we're going to put an end to it. So,
that is correct. And I think that's approximately what the courts actually do. When a medical error is so obvious, it's so clearly unreasonable, like saying, you're not getting general anesthesia, you're getting a shot of Jack or two, and then we'll hit you on the head and put a mask over you or a washcloth on your face. That even if other doctors would say, hey, yeah, that sounds good to me. That one, yeah, and you're right. It's not the best example because it's absurd. But there are instances of medical lapses where the plaintiff was told he or she did not need an expert because what the doctor did was so clearly unreasonable. So right. Yes, that's certainly right. I think the worry that you have is actually pretty well covered. And I know the museum talks about not only what tort law is, but what it could be, how it ought to change or consider modifying its beliefs. And I think part of it's longstanding conservatism makes it ripe for that kind of attention. Any system of jurisprudence that relies very heavily on precedent puts burdens of production and proof on people who want to change the status quo, has unequal access to lawyer time, sometimes lawyer talent based on ability to pay. These are all weaknesses to the extent we want tort law to be progressive. And I think the question of custom, where an entrenched industry might have no particular incentive to do anything different, is a good opportunity for for tort courts to do something progressive. The doctrinal holding, if you like, or teaching of T.J. Hooper is that courts are always going to be interested in custom when it arises, when the defendant says, I did or did not comply with custom, or the defendant says, I did comply with custom, I guess is the clearest example. And the plaintiff says, yes, you did, but that's not going to be good enough. Only in medical malpractice and the other professional malpractice categories like legal malpractice to a lesser extent is custom completely dispositive or almost completely dispositive, as we discussed. So typically the sector's custom will be available for us to talk about and introduce. And if there is a custom of safety and the defendant did not comply, the plaintiff can bring it up. If there's a custom of lack of safety, as here, like not bothering to have radios, the defendant will bring it up saying, hey, don't fault my radio decision. It's the perfectly correct way to do a tugboat. In 1928, courts are not bound by the compliance of the defendant with customs. So I feel that law and industries are talking to one another. The information about custom is a way for businesses and repeat players and activities to talk about what they do so that courts can learn about what they're ruling on. And the less than full bowing down to custom that Hand is insisting on is a way to be instructive to industry, saying that just because you want to do it and you like it and you're comfortable with the habit you're in doesn't necessarily mean that you can keep going that way forever. So ideally, there's a kind of symbiotic exchange of feedback or information that makes the operation of the industry better and also improves the quality of decisional law that courts produce.
Excellent. Thank you very much, Professor Bernstein. This has been very interesting.
Great to be here. Visit the museum.
Yes, thank you.